Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about retroactive application of new laws. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Lapointe was a doctor, and in the course of his practice, he was accused of, and ultimately admitted, being sexually assaultive towards some of his patients. During the course of his discipline, he agreed to a certain sanction, but between the time frame when he was disciplined initially to when his hearing wrapped up, the government increased the level of sanctions that you could obtain as a doctor for sexual harassment. And ultimately, the college sought the opportunity to strike him from the role of professionals. He argued that this violated his rights because if the punishment changed from when he was charged, or essentially when he was accused, to the time that he was disciplined by the disciplinary authority, he should get the benefit of the lesser punishment. Ultimately, the court agreed with him, and the college sought leave to the Supreme Court of Canada, which was denied. This case raises very important issues about the applicability of the rule against imposing older punishments in circumstances where the punishment has changed. In criminal law, the rule is very clear because you have a guarantee under the Charter, if you're charged with an offense, to have the benefit of the lesser punishment that's in place between the time that you are charged with the offense and the time that you're sentenced for the offense. But in circumstances of disciplinary bodies for professionals, these aren't offenses necessarily, even though the conduct may itself give rise to criminality like sexual assault. It's not an offense to be professionally disciplined. But in any administrative capacity, in any administrative body and decision-making, all decision-makers have to exercise their discretion in a manner consistent with Charter values. So this case raises a really important question about the applicability of provisions related to offenses in the criminal code that kind of mirror what's happening in the disciplinary sanctions and where those sanctions can have significant consequences to the individual. The applicability of the Charter principle is what is at issue here, even if the Charter doesn't directly apply to the conduct. And unfortunately, the Supreme Court of Canada missed the opportunity to get into what would be a very interesting, nuanced, and important discussion about the applicability of Charter principles to administrative decisions, especially when it comes to professional regulation and discipline. As we see more and more issues being resolved by tribunals across this country, more and more cases being sorted out through the tribunalization of issues that would otherwise be dealt with by the courts, and as we see provincial governments exercise more and more control over regulating professionals, moving away from self-regulating models, it is important to understand the scope of the rights and how they apply to these professional bodies and the scope with which Charter values apply. Although the Supreme Court of Canada has rendered decisions dealing with Charter values in the context of administrative decisions, those decisions really leave an incomplete body of how this actually applies to very specific Charter principles. And each Charter principle is interpreted and applies and is exercised differently. And so the opportunity for the Supreme Court of Canada to weigh in on this punishment component, especially because it can help with the timely resolution of discipline cases and provide certainty for people in the administrative process, especially for victims who are part of this administrative process, is important. Hopefully the Supreme Court of Canada gets another opportunity to delve into the question of retroactive applicability of punishments in administrative schemes, but it'll take another case going to the Supreme Court of Canada for that to happen. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenville Creative for putting together these videos. Please like, subscribe, and share with your friends.